So before we begin, I would like to invite our esteemed guest, Mr. Sumit Mohanty, to briefly introduce themselves and share a little about their experience in the field of succession. Welcome to our
Okay,
webinar, sir.
thank you. Thank you. And I heartily congratulate and I am grateful to have myself in this concerned program. So I am really obliged and honored to have myself in this program, great program. So my practice actually started since 2004, March 2004, and I was a associate to learned senior Mr. Ramakant Mohanty. He is a designated senior of Odisha High Court, and basically our practice was confined to civil and criminal litigations in High Court. And thereafter, I started my independent practice since 2010, sorry. And since 2010 till date, I have ventured into all uh, the litigation fields like civil courts, DRT, consumer, armed forces tribunal, DRAT, state administrative tribunal, which has now been abolished, central administrative tribunal, educational tribunal. In all spheres, I have got little bit of experience, and I have always tried my level best to get success and to give some relief to my clients.
That's amazing, sir. We are
So
pleased to have you with us today. It's amazing, sir. You have
thank
got
you.
a great experience. Okay, so sir, let me begin with the very first question. It is a very common question yet very relevant. What are the most common mistakes people do while writing a will in India?
So actually, will, as you know, it has been defined under the Indian Succession Act. So there is a definition of will uh, that has been enshrined in the Indian Succession Act. And the common mistakes which normally takes place or occurs is that there is improper witnessing. If the witnesses are not properly placed, then the will becomes a defective one, and which subsequently may be challenged in the. It would be easier for the person who has not got any benefit out of the will and who claims to have a right over the property. He or she can have a claim over the property by challenging the defective will. And next is your the person who is the beneficiary of the will. He should not be a witness to the will. So that will make more complicated situation, and it would be easier for the person challenging the will to get the will cancelled in the proper court of law. And next thing is the language. Language should be clear and lucid, and there should not be any ambiguity. The language should be in a clear manner. It should be the property description of the property. Everything should be completely and in a clear and unambiguous manner should be explained in the will.
Okay, sir.
And next thing is next thing is that the executant of the will should be of sound health, mind, and there should not be any coercion. So yeah, I suggest that if a doctor becomes a witness to the will, then the things won't be uh, defective or won't be under challenge. So these are the mistakes, and before executing a will, the executant should take proper legal guidance from a professional lawyer, so that he or she can be guided before drafting the will.
Okay,
And
that's
next,
great.
yeah, and there are also a lot of things which makes the will complicated and liable to be challenged before the court of law. And and that apart, uh, actually to prevent any untoward situation or any complications, the executant of the will uh, should be of conscious mind and should uh, uh, proceed with the drafting of the will with the proper guidance of the professional.
Okay, that's really insightful, sir. And I think people might be like they take these mistakes very lightly, but this cost them a long years of litigation in future. And that brings me to my
And
very
and and, and one more thing is that though will is not mandatorily required to be registered, but as far as practicable, we should the executant of the will should always try to register the will.
okay.
Register the will.
Okay.
A registered will is less prone to any kind of litigation.
Acha. Okay, sir.
Register the will.
So I would like to ask you one
And
question here.
and
Yeah.
another point is that we should always update the will. Suppose in case a beneficiary dies, and after execution of the will, the beneficiary dies. Then what? The will becomes infructuous. It has no it becomes odious. So we have to update so that if the executant wants to have their legal heirs uh, mm, as the beneficiary, then it has to be amended, or a fresh will has to be executed, and the schedule of properties have also to be updated, because it sometimes happens that this now it is, suppose this is 2026, the record of rights that we mention in the schedule of the will, sometimes it changes with the uh, coming of the new settlement operation, or the revenue department, they normally revise the plot and the details of the property after a operation, settlement operation or consolidation operation. They change the property schedule, so that has to be updated. Otherwise, if we go for probate, then we will have to face problem. And in princely states, for the knowledge of everyone, I would like to again tell that in princely states, will probation is not required. Once the will is executed, by virtue of a unregistered will also, the beneficiary after the demise of the executant can get the will mutated in his or her name.
Oh, that's really something new. I guess
Yes,
everyone will learn. That's a very
yes, yes,
insightful thing.
yes, yes.
So I would like to ask you three questions from what you have said. The first thing is a unregistered will valid?
Yes, it is valid.
It
It
is
is valid
valid, but we should
because
register it.
yes, it is valid because will has ultimately to be probated.
Hmm.
As per the Indian Succession Act, it has to be probated, and a probate case has to be filed before the concerned district judge of the state,
Okay.
of the district. Sorry.
Okay, okay. And so secondly, you have said that like we should avoid vague language. So can you like
Yes,
share a few tips of like what should the ideal will or what should be the ideal thing people should keep in mind while writing their will?
will can be drafted in English, Hindi, or in any local language. So the language should be clear. It should not be ambiguous.
Okay.
Should not be something like creating any doubt or suspicion in the probate proceeding. So the language should be clear, and the intention of the executant should be clearly revealed from the recitals of the will.
Okay. And so you have mentioned we should keep updating our wills, like we should keep our will updated.
Yeah.
So suppose
Yes,
I write a will and I forget to update it and I write a second will. So which one will be valid? The first one or the second one?
the last will prevail. The
Okay.
last will prevail. That is also the law, that if during the lifetime of the executant, will can be cancelled, and fresh will can be executed any number of times,
Okay,
many
okay.
number of times, and the last will prevail.
Acha. Okay,
Last
so
will executed by the executant will prevail.
okay, and so what if like in my first will I have my all requirements like witnesses and like everything, it is legally valid, but in my second will, the latest one, there is some issue with the witnesses. Then
Witnesses, as I have told earlier, witnesses should not be the beneficiary. Apart from any beneficiary, if the because witnesses are supposed to come and depose in probate case,
okay.
so their testimony has to be testified in by way of evidence.
Okay.
They, at the time of probate of the will.
Acha.
So the trustworthy persons are supposed to be made as witness in the will,
Asha,
so
can
that they will
we?
stand.
Please continue, sir.
Yeah.
Sorry for interruption. Please
So
continue,
so
sir.
so, so that yes, yes. So that if at all after the demise of and more importantly, will has to be the probate case should be filed within 3 years from the date of death of the executor. So, after filing of the probate case, the witness should support the will. Support means as and when required by the court, they should stand uh, for the beneficiary to
Okay.
get the will probated in his favor. If the witness they don't support at the time of probate, then the probate will be defective and the probate case may be dismissed on that ground.
Okay, sir. So one more question is there, like who should ideally be making a will? Like in India, I have seen many people they have a conception that no, only rich people or elderly people at the age of 60 they should make a will. So, like according to
No,
you,
no,
who
no.
should ideally be making a will?
See, a person who has a clear title over any property and who will be left, who will be leaving a lot of properties, he or she can execute a will. It is not a matter that a rich or a poor will only execute will. Will can be executed by anybody. After attending, after the age of 18, anyone can execute a will, not prior to 18. So 18 is the date of getting major and for executing the will.
Okay, so one more thing is there, like, why should people make a will? Like many people, I think in India there is not much awareness about the importance of will. So I would like you to speak a few lines on that. Like, why should people make a will, and like when should they start preparing for will and all everything?
Actually, will can only be executed by a person, he or she, only if they have a clear title over the property. And that apart, a person having a self acquired property can execute a will.
Okay.
Okay, a person having a clear title and having a property which is his or her self acquired can execute a will. And suppose in a family, the person executing, the executor has suppose 3 daughters, 2 sons. So it is his or her wish to execute a will in favor of any one of them. So that makes easier, and by virtue of that, the person to whom the executant wants to bequeath the property by way of will has the option, and she or he can go for a execution of a will.
Okay, so like in your practicing era, have you ever witnessed a case where due to vague language, people are fighting over a will?
Yes, yes.
So could you just tell us
Recently we
about
have
one
filed.
such?
Recently we have filed a suit challenging the will because the recitals of the will with regard to the partition of the property between the two sisters was not properly mentioned.
Okay.
Though the will got probated, though the will got probated and the will's probate certificate was issued in favor of one daughter, but it was the schedule described was ambiguous. So challenging that ambiguity in the present, the other sister she filed a suit before the concerned civil court. So it happens. It happens because other persons who have a interest over the property, they definitely will challenge the. They will try to make out loopholes from the will, and they will have a challenge to the said will executed by the executant in favor of the beneficiary.
Okay, okay, that's
So
great,
will
sir.
can be challenged on any ground, because not only the language, not only the witness, not only the scheduler properties, but the uh, uh, sound health, sound mental condition, health issues, that can also be taken as a ground while challenging the will. So, if a person wants to challenge and get the will cancelled and doesn't want to part with the property by virtue of the will in favor of the beneficiary, then he or she can challenge the will on any ground as stated by just now.
Okay, so like, is there any ideal eligibility for the witnesses, sir? Like, who can ideally be our witness? Like, as you said, or she should not be the beneficiary. So, what else
Yes.
requirements are there for the witnesses?
Witness some person who is known to the family, who is a close person, and a doctor is most vital witness if he has the age, so that after the demise of the executant he survives, then he can also become a witness, and it would be a very good suggestion to make a doctor as a witness, because doctor only, yeah, certifies that the person executing the will has a sound health and mind, and there was no coercion at the time of executing of the will.
Okay. So, you have mentioned that people can make a will whenever they have a title of ownership over any property. So, can we make a will for ancestral properties?
No, no, no. That thing I clarified just now. A few minutes ago, I told that a person having clear title over the property, if it is a self-acquired property, or it is a property which it is a, even though it is an ancestral property, and that person executing the will has got a portion of the ancestral property by way of partition or by partition deed or suit, and he has acquired a exclusive right over the property, then only he or she can execute a will.
Okay, so that's great.
If
And
he has a clear title, if he has a or if he or she has a clear title.
okay, and so like suppose I have written my will but I don't have a clear title over anything and I die, then what happens?
If I don't have a clear title,
Yeah, and I
then
just
then yeah, then the beneficiary will have to face a lot of legal.
okay, okay. So like what makes a will valid? Like what should people keep in mind so that like in upcoming years or after the that person dies who have written the will, that will gets executed properly without facing any problem, legal problem, litigation or any type of confusion.
As per my experience since last 24 years, what I suggest and what is my opinion is that a will should be in a clear language. There should not be any ambiguity, and the property description of the property which the executor wants to give it to the beneficiary should be properly mentioned, and there should not be any error in the will, execution of the will. And more importantly, if the will is registered, then it has a very bearing effect, and probate would be very easier.
Okay, so
I would always suggest that a will should be registered
hmm.
in order to avoid any future complication.
Okay, so like can we write a will on a normal plain paper or do we need a stamp paper for that?
No, for executing the registering the will, we need to write
And
it on
just
a
for
stamp
writing
paper,
it, sir?
and a plain paper will can also be probated.
Oh.
It once you don't register it, then a plain paper will also be can be probated through a probation case.
Okay, and so like regarding that updation of the wills, like what would you suggest? Like in everybody's life, there are few major events, like marriage, having children, or like buying a new property. So shall they update their wills at every steps, or shall they wait for the last moment?
No, it depends upon the executant actually, because if she or he has executed the will in favor of one of the son or daughter or brother or anyone from the family, and after the execution of the will, if that person was unmarried and she or he gets married, then it has nothing to do with that. Then there is no requirement of any amendment or any further fresh will to be executed, because the beneficiary is the same. Only in case of death of beneficiary, it has to be the fresh will has to be executed,
Oh, okay.
and the will executed by the executant in favor of the person who dies will become OTS.
Okay. So, is there any requirement like I have to write a will or I have to divide the property to my family members or close relatives only? Can't I just give it to my friend or neighbor who helped me or maybe my pet?
Yes, yes. in many cases that happens, and the will gets provided. It's not mandatory you should give it to your blood relation or son, daughter, or anyone, or grandchildren. You can also give to anyone who was standing beside you during your last stage of life and who has done something for you. It is your wish. Will is the wish of the person having a property, clear title over the property, to give it to anyone of his or her choice.
Okay, that's really
The will is
insightful,
the
sir.
last declaration. Will is the last declaration.
Definitely, sir. I think the questions you have answered very nicely, and I think our audience are going to get benefited from this definitely. Like for sure, I think that audience will love this, and many misconceptions will get cleared because people are now be like they rely on social media posts rather than just going and researching the entire thing. There are many myths regarding wills and like nominee legal heirs. So yeah, definitely. So you cleared our misconceptions and very interesting points you have said about the princely estates and all, and doctors should be our witnesses. So these things are really something unique which we are which we hear from you. It was an amazing session. So
Thank you once again for having me in your program. Great program. So anytime, any query, further query, I am always there. We can have some sessions, and we can be of help to the common person.